What if I told you the absolute quickest way to banknote a charity isn't, a failed fundraising gala, but just a single missing sentence in a receptionist's offer letter?
Right. It sounds absurd, but it's true.
It is. So today we are opening a trapdoor because usually when you think about running a nonprofit, you picture this incredible environment of, well, heart and mission.
Yeah, people coming together to make the world a genuinely better place.
Exactly. You imagine the focus is entirely on the people you're trying to help.
And I mean, that is the absolute center of gravity for anyone entering the sector. The mission dictates your daily reality. But the danger is that this deep emotional commitment, it often creates a massive blind spot.
A huge one.
Yeah, regarding the actual operational machinery required to just keep the doors open.
And that blind spot is made of complex, highly unforgiving regulatory compliance. Because if you fall through that trap door, you aren't just facing, like, a minor administrative penalty.
No, not at all.
You are facing the kind of financial liability that can literally destroy an organization's ability to deliver on its mission. So welcome to the deep dive.
We're so glad you're here.
Yeah, if you're sitting on a nonprofit board right now, or if you ever plan to, this is for you. We are unpacking a really comprehensive roadmap to Ontario employment compliance. It was specifically written for charity directors by Dov Goldberg of B.I.G. Charity Law Group.
And what makes Goldberg's analysis so vital is that it completely strips away all that theoretical jargon.
Right.
We aren't just looking at a dry list of labor codes today.
Right.
We are looking at the exact mechanical failures that cause well-intentioned charities to just collapse under legal weight.
So our mission today is to walk you through those specific high-stakes legal pitfalls. Let's just start with the foundational problem. Before a charity can even begin to manage a team or execute a mission, it has to legally define who that team actually is.
Right, the classification trap.
Yeah. And my assumption would be, if I'm running a tight budget, I can just hire freelancers, have them send me an invoice and skip the payroll headaches entirely. That seems like a logical, efficient way to manage donor funds.
It does seem logical, which
Yeah.
is exactly why it's incredibly common. Administrative resources in the nonprofit sector are historically really thin,
Totally.
but the Canada Revenue Agency, the CRA, they do not accept a working classification just because both parties wrote independent contractor on a piece of paper.
Okay, let's unpack this. Wait. If both the charity and the worker sit down, look each other in the eye, mutually agree to a contract relationship, and sign a contract saying so,
Yeah.
my instinct is that freedom of contract should win out. Why does the CRA get to override a private mutual agreement?
A great question, because it does feel unintuitive to have the government just step into a private agreement. But employment status isn't actually a private matter. It's a matter of public law and taxation.
Oh, I see.
Yeah, the entire Canadian social safety net, employment insurance, the Canada Pension Plan, it all relies on payroll tax contributions.
Right.
If employers and workers could simply opt out of those public systems by slapping the word contract on a piece of paper, the tax pool would completely collapse.
That makes sense. It's like taking a beef burger and slapping a vegan label on the packaging.
Exactly.
The label doesn't magically change the ingredients inside. If the ingredients of the job are strict control and zero financial risk, it's an employee.
Yeah, furthermore, you cannot contract your way out of statutory worker protections. The law fundamentally assumes a power imbalance between an organization and a worker, so the state intervenes.
So what are the specific ingredients the CRA is looking for?
They use a highly specific set of tests. The primary ones are control, ownership of tools, chance of profit versus risk of loss, and integration.
Okay, so control means asking who dictates how, when, and where the work is completed.
Spot on. And tools are fairly literal. Who owns the laptop or the software?
And profit and loss.
That one asks a crucial economic question. If a project goes drastically over budget, does the worker actually lose money out of pocket? Or are they just comfortably billing their hourly rate regardless?
Right, because a real business takes on risk. I want to pause on that fourth ingredient you mentioned, though, integration. How embedded is the person in the core operations?
Yes, that's a big one.
I look at this like the difference between a biological organ and a prosthetic.
Oh, I like that.
Right. If you hire an external plumber to fix a broken pipe at your headquarters, they are a prosthetic. They do a specific job, they leave, and your charity continues to function.
Right.
But if you hire someone to design your daily programs and manage your staff, they are a biological organ. You cannot remove them without stopping the heartbeat of the organization.
That is a phenomenal way to evaluate it. And
Mhm.
Goldberg highlights a brilliant case study of this organ versus prosthetic test just failing in real time.
The mental health charity one.
Yeah. So they hired a grant writer. They agreed she'd be a freelancer. But let's look at the ingredients of her daily life. She worked 30 hours a week exclusively for them.
Okay.
She used a computer provided by the charity. She sat at a desk in their physical office space. She had to follow their exact internal procedures, and she was directly supervised by the executive director.
Oh, man. She was a biological organ.
Totally. And when the CRA audited that charity, they looked at that setup and immediately reclassified her as an employee. The label meant absolutely nothing.
And the financial fallout.
It was an unexpected $18,000 bill for back payroll remittances.
Wow, 18 grand.
Yeah, that's the CPP, EI, and income tax withholdings the charity had failed to collect, plus penalties on top of that.
I mean, for a small charity, that is an existential threat. So the key takeaway for you listening is to aggressively audit your current freelancers. If they don't have their own risk of financial loss, they are likely employees.
Exactly. So if you successfully navigate that CRA gauntlet and officially hire an employee, the trapdoor doesn't close. It just shifts.
Shifts to the paperwork, the actual employment contracts governing that verified relationship.
Right. Getting the initial contract wrong makes ending the relationship an absolute financial nightmare.
I read the section on termination clauses and my jaw dropped. There is a case involving an environmental charity that hired a program coordinator.
Oh, this one is rough.
Yeah. They used a simple, friendly offer letter stating that employment could be terminated with reasonable notice. And then funding cuts hit, and they were forced to lay this coordinator off.
And reasonable notice sounds perfectly fair to the average person.
It does.
But legally, it's a loaded phrase. Because that letter lacked a highly specific enforceable termination clause that explicitly tied severance to the minimum set by the Employment Standards Act, the ESA.
So what happens then?
The courts default to what is known as common law.
I hear that term a lot, but let's break the mechanics down. Why does common law trump the basic statutory minimums? And why is it so dangerous for an employer?
Well, statutory minimums are just that. They are the absolute floor established by the government. Common law, on the other hand, is judge-made law evolved over centuries.
Okay.
And common law operates on the principle that losing your job is one of the most traumatic events in a person's life. It exists to bridge the gap between jobs.
Right.
So instead of just giving you a flat 2 weeks per year of service like the ESA might, a judge using common law evaluates the so-called Bartle factors.
Which are what?
The employee's age, their length of service, the specialized character of their employment, and the current economic difficulty of finding a comparable position.
Which means the severance calculation becomes entirely subjective and heavily weighted in favor of the employee.
Exactly. In the case of this environmental charity, the ESA minimum would have owed the coordinator about 2 weeks of notice, which was roughly $1,200. But because they used that vague, reasonable notice phrasing, the common law calculation dictated 8 months of notice.
Wait, 8 months?
8 months. A $32,000 payout instead of $1,200.
That is a $30,000 penalty simply because a board of directors didn't want to pay a lawyer to review a 2-page offer letter.
Exactly. The contracts must be legally ironclad, and they must be updated regularly as the law evolves.
But the text also points out a secondary termination risk that has nothing to do with the contract itself, right? It's the behavioral risk.
Yes, even with a perfect contract, how you fire someone can blow the whole thing up.
Right, because charities are high-stress, low-resource environments. Emotions run really high.
They do. Goldberg documents a social services charity terminating a communications director for poor performance. During the meeting, the executive director lost their temper.
Oh, no.
Yeah. Called the employee incompetent right to their face, and did so in front of an HR volunteer who was supposed to be an impartial witness.
That is a disaster. The employee sued for wrongful dismissal, right?
They did. And the court awarded $45,000 in punitive damages.
My read on this is that punitive damages aren't about compensating the employee for lost wages. They are specifically designed by the court to punish harsh, vindictive conduct by the employer.
That's exactly right. People in nonprofits view their work as a calling. So when things go wrong, it feels deeply personal.
So if you are a director, your policies must be designed to protect the organization from its own emotional worst impulses during a crisis.
Precisely. And that emotional investment leads us directly into another massive operational paradox.
What's that?
Well, we've been analyzing the severe financial risks of paying people incorrectly or firing them improperly. But there's an entirely different category of workers who cost you $0 in payroll, yet expose directors to the highest levels of personal criminal liability.
Volunteers.
Volunteer.
It is so easy to assume that because money isn't changing hands, the legal duty of care just disappears. You think, hey, they're just helping out of the goodness of their hearts.
What's fascinating here is that the law increasingly views volunteers through the exact same lens as paid employees when it comes to organizational responsibility and safety.
Really?
The exact same lens.
Yes. Section 217.1 of the Criminal Code creates a sweeping legal duty for anyone directing the work of others. Directors can face actual criminal prosecution if they fail to take reasonable steps to prevent bodily harm to workers and volunteers.
I want to make sure that lands for everyone listening. We are talking about criminal liability.
Yeah.
Handcuffs and jail time, not just an insurance deductible.
Yes, handcuffs.
So if you have volunteers, you need a structured legal framework, starting with intensive screening. Our research highlights a youth sports charity that completely ignored this.
Yeah, they utilize volunteer coaches without written agreements and without background checks. And the inevitable nightmare scenario occurred. An accusation of inappropriate conduct with children against one of those unscreened volunteer coaches.
Because they lacked a screening framework, the fallout was catastrophic.
Right, there was a human rights complaint, and the total loss of backing from a major funder who deemed the charity grossly negligent. Plus, over $25,000 in legal costs just trying to manage the public relations and legal crisis.
It's devastating. Any role dealing with vulnerable populations, children, the elderly, individuals in distress, it legally requires enhanced screening, including vulnerable sector checks.
You cannot skip this just because someone is offering their Saturday afternoon for free.
You can't. And that physical and psychological safety requirement, it extends to the physical environment itself.
Right, like the community garden charity example.
Exactly. Goldberg outlines a community garden charity that hosted a weekend volunteer workday. They had people operating power tools and performing heavy lifting. But the charity provided zero safety training. They had no occupational health and safety committee. And critically, they lacked insurance coverage for volunteer injuries.
See, I look at volunteers the same way I look at guests invited into my home. Just because my guests aren't paying rent doesn't mean I'm off the hook if my living room roof collapses on them while they're sitting on my couch.
That's a great analogy.
Right. I am entirely responsible for the safety of the environment I invite them into. At the community garden, a volunteer suffered a severe back injury while lifting equipment.
And because there was no safety infrastructure, the board chair and the executive director were personally named in the resulting lawsuit.
That is terrifying.
It is. And this extends to specific regulatory clearances, too. If your volunteers are doing anything resembling construction work, the charity must secure Workplace Safety and Insurance Board, or WSIB clearance certificates before a single hammer is lifted.
So the law demands proactive protection, not reactive apologies. So if a charity is surrounded by financial landmines from misclassified employees and contract errors and criminal landmines from unsafe volunteers, how do you actually enforce these boundaries day to day? Like, how do you build a defense system?
The defense system is a comprehensive, actively enforced policy shield. Policies are the operationalizing of the law.
Okay, what does that look like in practice?
They are how a board of directors explicitly communicates to the staff. This is how we comply with our legal obligations. Without them, chaos is the default state.
Let's examine a few specific policy failures to see what that chaos looks like. Take a simple background check policy.
Oh, the food bank example.
Yeah, a food bank hired a warehouse coordinator without a criminal record check. The logic was likely, it's a warehouse, they're just moving boxes.
Right. But that coordinator had access to the charity's donor database, which contained home addresses and personal contact info.
And that lack of a policy resulted in the employee being arrested for identity theft involving stolen mail.
Yeah. And because the charity failed to perform basic due diligence, their insurance company initially denied coverage for the related losses. It just plunged the charity into intense police and financial scrutiny.
Wow. Then there is the requirement for a workplace harassment policy. A small arch charity decided they didn't really need one. They assumed they were a small, progressive, friendly group.
Right. But a board member began making inappropriate comments to an administrative assistant.
And when there is no policy, there is no reporting mechanism and no neutral investigation protocol.
Exactly. The administrative assistant had no safe avenue to escalate the issue, so it just festered until it exploded into a $15,000 human rights complaint.
And the internal chaos was so severe that 3 board members resigned, completely fracturing the organization's leadership.
It's a huge ripple effect. And what about conflict of interest policies?
Yeah.
A health advocacy charity had a part-time bookkeeper who was secretly working for a pharmaceutical company.
A company the charity was actively and publicly criticizing in their campaigns, right?
Yes. And because they didn't have a conflict of interest policy that explicitly demanded disclosure, they had no clean legal mechanism to terminate the relationship immediately. Untangling that mess disrupted their financial management during a critical funding period.
So these aren't theoretical risks. Policies literally dictate organizational survival.
You really do.
I do have a question about hiring policies, though, specifically regarding religious charities.
Okay.
If a charity has a deeply specific religious mission, can they hire or fire based on an employee aligning with those values? Because my read of the Human Rights Code is that you cannot discriminate based on creed or religion.
The legislation here is highly nuanced because it attempts to balance 2 competing fundamental rights: the right of an individual to live free from discrimination and the right of a religious or special interest organization to maintain its core identity.
Right, that makes sense.
So, under strict limitations, religious charities can require employees to sign lifestyle statements aligning with their faith. However, this must fall under the specific Human Rights Code exceptions for special interest organizations.
Meaning what, practically?
The requirement must be a bona fide occupational requirement, meaning the religious adherence must be functionally necessary to perform the job, not just a blanket preference applied to every contractor or warehouse worker.
Oh, I see. So it has to be objectively tied to the actual duties of the role, and it will be heavily scrutinized if challenged.
Exactly.
So what does this all mean for charities trying to keep up today? Because employment law isn't a dusty book. It evolves alongside society.
It means the compliance landscape is constantly accelerating.
Mm.
Goldberg's guide points out several modern hurdles that are currently catching directors off guard. We don't need to list every single one, but we should deeply examine 3 critical areas:
Okay, what are they?
accessibility, intellectual property, and competition.
Let's start with accessibility. I think most organizations know they shouldn't discriminate against individuals with disabilities, but the text outlines very specific regulatory thresholds under the AODA, the Accessibility for Ontarians with Disabilities Act.
Yes, the AODA is not just a suggestion for inclusivity. It is a strict regulatory framework.
Right.
If your charity hits the threshold of 50 or more employees, the legal requirements shift dramatically. You are legally required to prepare comprehensive, multi-year accessibility plans, post them publicly, and actually file formal compliance reports with the government.
And failing to track your headcount and missing that threshold exposes the organization to severe administrative penalties.
Exactly.
What about intellectual property? This feels like an area nonprofits completely ignore because they aren't tech startups. But if an employee or a volunteer creates a new training manual or designs a logo or writes proprietary grant templates, who owns that?
By default, the creator has significant rights. This is why charities must secure 2 specific things: copyright assignments and moral rights waivers.
Okay, copyright, I understand. That's the legal ownership of the manual so the charity can reproduce it. But what is a moral right?
It's a fascinating piece of law. Even if an employee signs over the copyright, Canadian law grants the creator moral rights.
Which
It means the creator retains the right to be associated with the work by name, and critically, the right to prevent the work from being modified or changed in a way that prejudices their reputation.
Wait, really?
Yeah. If a charity wants to update a volunteer manual 5 years from now, and the original author claims the edits ruin their creative vision, the author can legally block the changes, unless they explicitly signed a moral rights waiver when they wrote it.
That is wild. You could literally have a disgruntled former volunteer holding your operational manuals hostage because you didn't get a moral rights waiver.
Exactly. It happens.
Okay, the third modern hurdle you mentioned was competition. How does competition law apply to charities? They aren't corporations fighting over market share.
No, but they compete for talent. Amendments to the Competition Act have actually criminalized wage fixing and no poaching agreements between employers.
Okay, so give me an example of how that plays out.
Say, two rival charities in the same city are tired of losing staff to each other, and the executive directors informally agree over coffee not to hire away each other's program managers just to keep wages manageable.
Right.
That is now illegal anti-competitive behavior.
A casual coffee agreement between two directors just trying to save donor money could trigger a federal investigation.
Exactly.
Synthesizing all of this, the reality for anyone involved in nonprofit leadership is stark. Auditing your working relationships, constantly updating contracts, securing moral rights waivers, enforcing safety policies. These are not annoying HR administrative chores.
No, they're not.
They are the foundational armor protecting the charity from oblivion.
And the ultimate bottom line derived from Goldberg's work is an economic truth. The cost of proactive compliance is always less than the cost of failure.
Paying for a lawyer to draft a proper termination clause costs a fraction of a $32,000 severance payout.
Exactly. Paying for a background check is infinitely cheaper than losing a major funder due to negligence.
Next week on the Deep Dive, we're continuing our exploration of director liability using this exact roadmap, but we are shifting our focus to financial management risks. It is a critical piece of the puzzle for anyone sitting on a board.
It really is. It requires the exact same rigorous, unemotional oversight as the employment issues we explored today.
As we wrap up this analysis of employment compliance, I want to leave you with a lingering thought. We started by talking about the deep emotional commitment to a charity's mission.
Right.
So ask yourself, if an organization's ultimate goal is to improve society, advance a cause, and protect the vulnerable, how does failing to legally protect its own workers and volunteers fundamentally contradict the very mission it is trying to achieve?